Ladies and gentlemen, welcome to the webinar. Today's webinar presentation is from our first 30-minute series. Today's seminar topic is asset protection for healthcare providers in the COVID-19 era, an ideal time to plan. Today's presenter is attorney Eric Boughman. If you'd like a copy of today's presentation, you'll find it in the handout section of the webinar interface. Similarly, if you have a question, you can type it into the questions section of the webinar interface. With that, I'll hand it over to Eric. Go ahead, Eric.
All right, good afternoon, everybody. Thank you for joining us for another in our series of the first 30 minutes. We're doing these at least on a monthly basis, and we did one last week on telehealth, focusing on how physicians and healthcare providers in this era can make sure they get paid for the work that they're doing. Today, we're going to talk about how to make sure you keep what you earn. And as we put here in the title, this is an ideal time to plan, and I'll explain why that is shortly. If you have questions along the way during the next half hour, please let me know by putting it in the chat box, and I will try to address it. If I don't get to a question during the webinar, I will be available to answer questions if you want to shoot me an email or give me a call. My contact information is at the back of the slide. And with that, we are going to move into our presentation. So this is the agenda we're going to discuss, and this is what we go through with every client when we're doing an analysis of their situation with respect to personal asset holdings and business asset holdings. We start off with an assessment, and then I'm going to talk about just some pretty straightforward components, things you can do, some of the things you'll be able to do yourself, and some you may want to seek advice on. But for all these items, they're things that you're going to be generally familiar with, and I'm going to explain why they are key to your planning. And if we have some time in the back end, I always include a few just additional thoughts or pointers that don't really have a place where I cover them in the presentation generally. And we'll hit on some of those at the end, just some random thoughts that come up as I'm putting this material together. And as I've said, it is an ideal time to plan. And the reason is that whenever you're doing asset protection planning in particular, there's a chance that your motives are going to be questioned. You know, with healthcare providers, with physicians, you know, the old adage is there's two types of doctors: those who have been sued and those who will be sued. And so when you go to an attorney or you seek out advice on how to protect your assets and you find somebody who does asset protection, there's a chance that later a court or somebody taking a look at your actions are going to ask the question, you know, what were your motives? What were you trying to accomplish? Were you trying to hide assets or do something unsavory? And that's really unfortunate, because the law is designed in such a way that you can plan in advance by protecting assets, as long as you do it when you don't have any claims on the horizon. You know, essentially when the skies are sunny like they are today, you can engage in planning to protect yourself both on the corporate side and on the personal side. So nobody ever questions why somebody would start a business in an LLC or a corporation for liability protection. And people don't typically question why you might, in Florida, for instance, purchase a Florida homestead as part of your asset holdings, knowing that there are protections in place for you to keep your homestead. Or no one would question why you might create a trust for the benefit of your kids or for someone else with respect to certain assets. But when you put all that together and you call it asset protection, for some reason there's still this notion that you're doing something wrong. And the reason for that is really has to do with a misconception about what asset protection planning is. It's not hiding assets. It's not reacting to claims by creditors. It is engaging in advanced planning, using existing laws and structures and contracts in order to protect your assets and essentially save for a rainy day. The keys to effective planning are timeliness. As I said, you have to do this in advance for it to really be effective. Too often we see clients who have something bad happen, they have a claim, maybe a loan goes bad, a business arrangement, they get sued. It could be anything from a malpractice claim to a car accident, and then they decide to seek out help and they want to contact somebody about asset protection. And generally it's too late. You can't do anything, because at that point you're reacting. And one thing that we always counsel clients to do is to plan, don't react. When you're reacting, it looks like you're trying to hide assets from creditors, and then you run into this issue of late timing and implication of fraudulent transfers. People have heard the term fraudulent transfers, and essentially a fraudulent transfer is a transaction where you move an asset with the intent to avoid a creditor. Now, who's a creditor? That could be anybody from a lender on a transaction, particularly if it looks like it's going to go into default, to a client or a patient in a procedure that goes bad. That person, if they make a demand, if they file a claim, if they sue you, that person becomes a creditor. There are different types of creditors. We have, under the statute, you have future creditors and you have present creditors. There's some gray area as to exactly what that means with respect to each. But if you get sued, if you have a demand, you now have a creditor. Oftentimes, for a lot of professionals, there's many times when you're going to have a creditor of some stage, whether it's a future creditor or a present creditor, and you need to plan around that. And so when you are looking at your situation for an assessment, you have to be, what we also counsel is to tie your protective planning, particularly your personal asset protection, into something else, into a corporate restructure or corporate planning, into estate planning. We've actually done seminars in the past where the title of it is Don't Do Asset Protection. And it's not that we don't think people should engage in actions that will protect their assets. It's instead that the way you present the plan makes a difference. And you want it to look like you're planning in advance for essentially for a rainy day and not reacting. So why do we say now is an ideal time to plan? Well, because of coronavirus. Normally, you'll always have to answer the question or be ready to answer the question later. Why did you engage in whatever planning you did? Why did you move these assets into this structure, into a trust, or move things into an LLC, or create a holding company structure? And then there's questions around that. And if you have creditors, then a creditor is going to say, well, you did that to avoid a creditor. Well, with COVID-19, and the national epidemic that we're dealing with today, I envision that the next few years, this is going to be everybody's answer to why they engaged in planning. And in fact, we've been, even though things have been quiet generally on the business front, our office has been pretty busy with people calling, updating estate plans, wanting to know where they stand, both from a personal standpoint and also from a business standpoint with business structuring. People are nervous, and things like what we're dealing with today make people reconsider where they stand personally and will cause people to engage in protective actions. So nobody's going to question why a healthcare provider who's on the front lines of what we're dealing with wants to update their estate plan and their will. And by the same token, for the next couple of years, I think that this atmosphere that we're going through gives everybody a reason to reevaluate where they stand, and it gives you an explanation for why you did what you did. And while we generally counsel against fraudulent transfers, I would say that if there's ever a time that there's a questionable transaction that you were going to engage in and you had a reason, what might be referred to as a legitimate supervening cause or reason for a transaction, right now this environment with COVID-19 presents that. And that's why now is an ideal time to plan. So the first thing we do when we engage in personal planning analysis is we want you to do an assessment. And you can do this yourself. You can do it with your attorney. We have a form that we use that we ask people to fill out and provide to us. But this is something that you should do on your own as well. Take a look at your personal holdings. Take a look at your business holdings. See how you own things. How are things titled? Do you have insurance in place? What type of insurance do you have? Is it enough? I'm a big proponent of having a high policy limits on your insurance because insurance provides great low-hanging fruit to protect your other assets. For your business holdings, do you have separation between your business? For instance, if you have a healthcare practice and you own the building that you practice in, do you have those assets separated? You should have them in different entities. Do you have more than one line of business running through your business assets? In some regards, healthcare providers in particular are subject to regulation under corporate practice of medicine doctrine, and similar concerns where how you own certain business interests is limited. So you need to take advantage of the fact that you can own non-regulated business lines in separate entities and create separation. Also, look at your personal holdings, look at your estate plan, look at how things are titled, your bank accounts. If you're married, tenants by entireties bank accounts provide excellent protection, particularly if you're in a situation where your spouse does not either doesn't draw employment income, stays home, takes care of family at home and so forth, or if your spouse is in a low risk environment where they're not at risk for being sued. Professionals like doctors and lawyers and accountants and other advisors and fiduciaries are in a position where they can be sued in essentially a high-risk position for being sued. And so by making your assets as much as possible owned as tenants by entireties with you and your spouse, you create some protections that are very easily achievable. Again, an insurance review, I suggest that you have an insurance agent that you work with, some type of risk management advisor who can make sure that you're properly covered. And if you have any questions, go back to that person. If you are engaging in a new line of business and you need coverage, I always suggest that people go back to their advisor in this area and make sure that they're properly covered to deal with risk. And finally, I mentioned earlier, if you do have existing claims right now, or if you're concerned about existing claims, you really want to understand the distinction between what assets are exempt and what assets are potentially exposed. And the reason for that is that if you have claims where it creates limitations on what you can do with your exposed assets, you can't transfer them now because of the existence of a claim and the fraudulent transfer risk. If you have an option for what assets you're going to use in your daily expenditures, you want to burn off as much as possible exposed assets and preserve protected assets. Pretty simple function when if you run into trouble, but you have to understand what things are protected and how they're protected in order to engage in that type of simple strategy management. So I'm going to walk through, as I said, 5 what I think are pretty straightforward components of asset protection planning, things that you can do. Again, a lot of this you can do without counsel, or if you're advising other clients for some of our other professionals out there, accountants and financial advisors that are working with folks in the healthcare profession. These are the things you should be looking at with your clients. First, again, is insurance. To the maximum extent possible, I recommend that you insure against risk. High policy limits on auto policies, umbrella coverage, malpractice coverage. Make sure you're covered for tail coverage if you've made a move. Make sure you have proper liability coverage for other business interests. If you own another business, if you own real estate, make sure you're covered there. Pretty simple way to, again, create low-hanging fruit so that if you do have the threat of a lawsuit, you can take your protected assets, segregate those, keep those over on the side, and offer the low-hanging fruit of insurance to settle outstanding claims. And when you're properly insured, that strategy alone is very, very successful. Very good chance that you're going to be able to use insurance to resolve outstanding claims. And if you have questions about that, if you have questions about your coverage, I'm certainly no insurance professional, but I certainly know folks, and I'm happy to try to point you in the right direction. Second of our 5 components, again, proper titling. I mentioned earlier, tenants by entireties. It's a simple concept. The idea of tenants by entireties is if you have a husband and wife who are married, or now it could be a same-sex couple spouse that are married, a claim against one of the individual spouses does not touch marital assets if they're properly titled as tenants by entireties. Think of a bank account. If you have a bank account that's properly titled as a marital bank account, owned tenants by entireties by husband and wife, then a claim against the wife or the husband individually, regardless of what the claim is for, is not going to touch those marital assets. Very easy way. So I'm a lawyer. My spouse is home, takes care of our kids. We have a bank account, and the bank account is owned as a tenants by entireties bank account that we operate out of on a day-to-day basis. if somebody tries to sue me, they can't touch that bank account because it's a marital account. Now, there's some common issues that people run into. First of all, some banks don't offer tenants by entireties accounts, so you first need to figure out if it's even offered. Second, it has to be titled properly. Pretty simple to do when you do it all the time, but it can get a little bit tricky. For instance, if you have if you have an account that's owned by just one person and you want to make it a TBE account, you can't do it. You really need to close the account and reopen a new account with you and your spouse as tenants by entireties. Too often people will try to just change the account or change the titling, and you can't do that. You have to actually meet the requirements of tenants by entireties, and that involves taking title on the same document at the same time as husband and wife in the proper form. Beyond that, once you own things as tenants by entireties and you make that clear, it offers pretty simple, pretty good protection. And if you have any questions on this, what I tell folks all the time, I have other advisors that will call me on a regular basis. Again, accountants, other folks, they're helping folks open up accounts. They call. I've even had folks from the bank send me the forms so I can take a look at them. If I can help in any way, let's make sure that that's done right, because it's a really simple way to protect yourself. And then on other titling issues, make sure that you're keeping, again, your personal and your business holdings properly titled and separate. Don't commingle those. Don't create reasons for additional risk. For instance, again, I come back to, because I've seen this, if you own a healthcare practice, or if you have a client who owns a healthcare practice and they own the physical building or structure where they're operating, those should be titled as two different entities. There's no reason to expose one asset to the risks of the other. Simple in theory, not too difficult to accomplish, but you want to make sure that you have that in place. And if you don't, then raise questions and let's get that fixed. Finally, I put a note down here. Cars, all the time I see folks, I deal with folks who have a spouse, a child, adult child driving their car, get in an accident, and now they're exposed because they're the owner of the vehicle. Do not co-title vehicles. Make sure you own the vehicle you drive, and don't have your name on vehicles that you don't drive. Cars are not assets. They are liability machines. Third in our 5 is exempt assets. And exempt assets are typically designated exempt by statute. These are things such as your homestead, which is actually a constitutional protection in Florida. Different states protect homesteads to a different extent. Florida is one of the best states for homestead protection in the country. If you have a homestead in Florida, it's generally exempt from creditors with very limited exceptions. The exceptions would be for a mortgage on that home, for any liens on loans for home improvements, and for any fruits of fraudulent activity. So you can't rip somebody off and put that money into a homestead. But otherwise, the homestead is one of the greatest protections. Is a constitutional protection here in Florida. A couple other states offer the unlimited homestead protection, and you need to take advantage of that. One other thing I'll mention on homesteads is it has to qualify as a homestead. Pretty simple, except for the acreage requirement when it comes to the difference between a homestead in a municipality and not in a municipality. Not as obvious as it sounds. I think the social and public policy is to protect properties such as farmland in rural areas, but you can be in different parts of Central Florida, where I live, for instance, and live in an area that's not in a municipality. For instance, I live in unincorporated Seminole County, and I can have a homestead of up to 160 acres. But I have, for instance, one client who has a home that they purchased. It's on the water, and it just happens to be in an area that was recently designated a municipality just within the last 15 years. And the home is over a half acre and would not qualify as a homestead. So if you have any questions on that, again, please let me see if I can help you out on that one very quickly. Just a quick phone call, email. Let's make sure you're on the right track. You can figure out if you're in a municipality or not simply by looking on the public records for your property and find out where it's located. Another one I put down here is head of household income that I call out. Because if you do have an action against you, some type of claim, you have a protection for head of household income. It cannot be garnished or attached. Generally speaking, there's some limited exceptions, but you need to make sure that you're segregating those funds and employing proper protection. Beyond that, things like education accounts, life insurance, annuities, retirement accounts, these are all statutorily protected, very broad protections in Florida under the statute, and you should absolutely be taking advantage of those. The question I see sometimes is folks who get sued and say, well, can I contribute to my retirement account now that I've been sued, or is that going to be a fraudulent transfer? Well, here's the way I typically answer that. It depends, what have you been doing? If you have been contributing on a regular basis, then by all means continue to contribute. But if you don't contribute, then if you start contributing because of or what appears to be because of a claim, you can have an issue. So establish the pattern now and make your contributions to these accounts, and you're going to see protection from that. And then again, if you do have a claim, if anybody has clients out there, somebody who's dealing with a claim or a potential claim, and you have questions on the mechanics of this head of household income, get with me offline. There's a strategy for how to segregate those funds that I go through with people, but I want to make sure that if you're in that situation, you're doing it the right way. All right, no questions so far, but I'm keeping an eye on the question side. Fourth of our 5 straightforward components is the wise use of entities. LLCs are really the best one for most people. That's what we prefer. You can use a limited partnership. You can use corporation. Corporations have some drawbacks to them because although a corporation protects the shareholders from liabilities that affect the corporation. So if you own a business or some type of asset in a corporation, you're protected to the extent of your contribution to the corporation, so that the suit doesn't come back against you individually, absent veil piercing, piercing of the corporate veil. You're generally protected. But if you get sued personally, if you get sued, for instance, on against a professional liability claim, and you have assets that you own as a corporation, that corporate stock can be taken. The same is not true of a multi-member LLC. If you own assets or real estate or something else in an LLC in Florida, it's a multi-member LLC. The most a creditor can get against that LLC is a charging order, which is essentially a lien on the proceeds or distributions if and when made. Most people tend not to make or call for distributions if there's a charging order. There is an exception for single member LLCs. There's a few potential workarounds. So if you are in a situation where you have a single member LLC, the easiest is to try to figure out a way to make it a multi-member LLC. Add a spouse, a business partner, trust for your children. There's some ways to do that, or maybe look at other jurisdictions that offer more protection, but definitely preferable to have a multi-member LLC. If you're in a single member, it still provides some protection, but not as much. LLCs, corporations, if used, I don't recommend them again, but mostly LLCs should be used generally to protect business assets. People want to put personal assets in LLCs. Every once in a while, that might be a good idea, but generally, we're going to use trusts for personal assets. You're going to use limited liability companies for business assets, with some small exception. You're also going to take, again, maximum advantage of the exemptions, the freebies that the Florida statutes give you. With respect to documents, it amazes me how many folks I see with LLCs that don't have any way of showing easily how the LLC is owned. Oftentimes we go back to tax returns, but tax returns are going to reflect whatever information you gave your tax preparer, your accountant, or whoever is doing your taxes for you. If you intend to have a multi-member LLC and you intend for it to be owned in a certain way, you should have an operating agreement. You should have certificates and a journal of ownership. There's additional advantages to having these documents. There are arguments that you can make when you have documentation that are not available to you if you don't have proper documentation. So it's not difficult to accomplish. Once it's done, it's generally done. LLCs, again, I like those instead of corporations generally because the ministerial requirements are less. You don't have to have annual meetings and minutes and so forth. but do your initial documentation, make sure it's done properly. I'll make a note about general partnerships. You shouldn't own assets as a general partner. The problem with general partnerships is that each partner is individually and personally liable for the debts of the partnership and any other partner who creates debts in that partnership to the extent they're acting within the scope of the partnership. So partnership, if there's anything that's worse than probably being a sole proprietor, it's a partnership, because now you've signed up for everybody else's debt. If you're in a partnership, it should be some type of limited liability partnership or consider the LLC. Finally, here, before I want to make a note, I think I mentioned this earlier, that again, with respect to your entity ownership, there's some limitations imposed on healthcare providers due to regulation. And this is why, especially in this industry, that separation is important. Something that we don't have to deal with in many other industries, but for instance, here in Florida, if you're a dentist, or if you have a client who has a dental practice, their dental practice must be owned by only dentists. They can't own that with a spouse or with other non-dentist partners, so they can't create a situation where they've limited or provided more protection by having a multi-member entity in some cases. In those cases, you may want to take a look at things like practice management agreements with a separate entity to break out other assets where possible away from the structure. It gets a little bit more complicated, but I just wanted to toss that out there, that when you're advising healthcare professionals, there are still some workarounds, but the corporate structuring becomes even that much more important. And lastly, trusts. Here's the thing to understand about trusts: is you are separating the legal title and the beneficial interest. And the idea is, if I have an asset and I put that asset into a trust, the trustee has legal title, but the trustee only has legal title for the benefit of the beneficiary. So if somebody tries to get that asset, they can't get it because the trustee is only able to control the asset for the benefit of the trust beneficiaries. Similarly, if the beneficiaries go out and get themselves in trouble, something happens, well, they don't have any ability to transfer legal title to the asset. It's essentially the oldest traditional form of asset protection, but you have to understand a couple things about trusts. One is, in order for them to be effective, you have to give up control, and control is often the key. If you have a revocable trust or a revocable trust, they're good for estate planning purposes in many cases, but they offer no asset protection value. So if you have a trust and it's a living trust or a revocable trust that you can change or you can alter, you're generally not going to have any protection. You not even generally, you don't have any protection as far as asset protection value goes. It needs to be an irrevocable trust with proper spendthrift provisions. Also, self-settled trusts, we get asked about those often here in our office. Florida does not allow you to create a self-settled trust. It doesn't matter if you have a corporate trustee or whatever else you've heard. Understand, people do create them here. From my understanding, they have no asset protection value. It will not work. There are other jurisdictions where you can create a self-settled trust. That's one where the grantor puts assets into the trust for the grantor's benefit. But those, again, a little more complicated, not something you're going to do on your own. If you have questions about those for you or a client, let me know. And finally, yeah, I walked through these 5 steps. And one of the most important things is for when you have a client who has an asset protection structure in place, at some point, if it's ever challenged, and hopefully it's not, hopefully it's like insurance, you never need to use it, but if it's ever challenged, the client needs to be able to understand why they did what they did and what they have. And that's why I suggest that, overcomplicating things can backfire. If somebody has to go into court or go make an argument, and your client gets called into court to explain why they have what they have and what they have, if they can't even explain it, I'm going to tell you that the structure is at risk, and I've seen it happen, unfortunately, too many times. And similarly, why did they do what they do? And again, I come back to, now is an ideal time, because for the next 3 to 5 years, people are going to answer that question with COVID-19 or coronavirus, kind of like the Denny Crane mad cow line from Law and Boston Legal that we heard for many years. Why'd you do that? Coronavirus. I'm not going to have time to cover these other issues, but I want you to know there's a few just points that I put here on the back side. They're in the slides that are available in your handouts. If you have questions about those, I welcome those. It's 12:31. We started at 12:01. And that's essentially the first 30 minutes of a conversation I'm going to have with most folks, clients, and advisors on asset protection, particularly why it's so important to take a look at where you stand now and engage in any protective actions that you might consider now while we're dealing with everything else that we're dealing with on a national level. With that, thank you again for joining me today. I look forward to next time. On the next one, we're going to do a legal update, again, on issues surrounding COVID-19. I can't tell you exactly what they are because they change day to day. There's just a new law, a new order that came out from the governor recently, another one affecting healthcare. We're seeing changes on payer provisions, specifically with telehealth on an almost daily basis. CMS is giving us updates, and we'll collate that material and provide you an update in the next couple of weeks when we're ready to join you again. And everybody be safe. Please engage in social distancing and have a great rest of your day. Thank you very much. Bye-bye.